Good morning. I'd like to call the June 9th Committee of Adjustment meeting to order at 9 a.m. And the first is the adoption of the agenda. Thank you. Moved by Member Bridgman, second by Member Grogan Green. Be it resolved that Committee of Adjustment agenda dated June 9th, 2025 be adopted. All those in favor? That's carried. Are there any declarations of conflict of interest? Moved by Member Grogan Green, second by Member Brown. Be it resolved that Committee of Adjustment minutes dated May 16, 2025 be adopted and approved as circulated. Any questions or comments? All those in favor? That's carried. Get my other pen. I thought I was
Good morning, everyone, and welcome. It is required that I make a few statements, then I will explain the hearing procedures. This electronic hearing is being held in accordance with Section 238 of the Municipal Act. The members of the Committee of Adjustment present are Alan Edwards, Barb Bridgman, Ruth Ann Brown, Lisa Grogan Green, and Sean Stokes. I can confirm we have quorum and that senior staff and planning staff are present. Public input on this June 9th agenda was invited at the following email address: planning@muskokalakes.ca. Now I will explain the hearing process. The planner will provide an explanation and the purpose of the application, the date the notice was circulated, and planning staff's comments. All internal and external submissions received by 8:15 a.m. today have been made available to the committee members and the public. These submissions can be viewed under Section 10 of the agenda. When able, planning staff will do their best to circulate submissions that were received after 8:15 a.m. These submissions will also form part of the public record and will be available for the public on the township's government portal. The planner will identify the source of each submission and whether it is in support or opposition to the application. Should committee members wish to view any submissions during the meeting, they may request that it be projected onto the council chamber's screen to view. The committee will hear from the applicant or the applicant's agent if they wish to add any information or to substantiate their proposal. Please provide your name, mailing address, and postal code for our records. The committee will hear from those in support of the application and those in opposition to the application. Again, please provide your name, mailing address, and postal code for our records. Presentations are limited to 5 minutes unless otherwise permitted by the committee. If you are here to speak on an application electronically, please wait until after the planner presents the relevant application to raise your hand in Zoom. If you are here to speak on an application in person, when asked, please raise your hand, and when you are recognized by the chair, please approach the podium, turn on the microphone, and remain at the podium while you state your comments for recording purposes. The committee will hear from the applicant or the applicant's agent to respond to any questions or concerns raised. The committee will then have an opportunity to ask questions, have a debate on the application, and make a decision based on the information presented at the hearing. Please note that the effect of written and oral submissions on decisions for consent and minor variances, along with the reasons for minor variance decisions, are both required under the Planning Act, and motions are pre-populated with standard wording. However, the committee may decide to add reasons and/or effects to the standard wording after voting on a decision. Motions have also been pre-populated with random movers and seconders to expedite the meeting. When it is time to vote, members shall physically raise their hand until the chair has confirmed the vote. If the vote is unclear, a verbal vote shall be recorded. This is not considered a recorded vote. It must be noted the chair has a vote on each application and can participate in the discussion. There is a 20-day appeal period from the date of the decision. Building permits are not available until after the appeal period and if no appeals are received. Lastly, please take down the pink notice signs that were posted on your property to advertise today's meeting. Thank you.
Thank you very much, Ms. Ward. And the first application is B 171819/25 ML, and that's Ms. DeMello.
Thank you, Chair Edwards. The first application to be heard is consent application B 17181925 ML in the name of MARSDEN and GRASSL. The subject lands are known municipally as 3 Hiawatha Lane. I would direct committee's attention to the submitted consent sketch on page 34 of the agenda package. The applicants propose to grant rights of way over portions of an existing driveway. Notice of this public hearing under the Planning Act was circulated 14 days in advance of this meeting, and 6 comments have been received to date. Comments were received from the district stating no objection to the application. Comments were received from Matt Veach, the township's Development and Transportation Engineering Coordinator, stating no concerns and noting that private roads are not required to be constructed or maintained in accordance with township road standards. The Public Works Department does not review this type of access. Road access for emergency services may be limited and/or unavailable via the proposed road access. Comments were received from Nick Snyder, the township's chief building official, stating no objection. Comments were also received from Douglas Holland, the township's fire prevention officer, stating no objection. A letter was received from Guy Wilson, located at 1 Hiawatha Lane, outlining concerns regarding the proposed right-of-way to be extinguished, as a portion of the existing right-of-way is currently used to access his property. A letter was received on Friday, June 6th from Trevor George, a lawyer representing the property owners located at 7 Hiawatha Lane, known as benefiting lot number 2, and 9 Hiawatha Lane, known as benefiting lot number 3, outlining concerns such as a misrepresentation of the retained lands on the consent sketch and a desire to defer the application until such time as private matters can be dealt with between the private property owners, and a more detailed consent sketch provided to committee members. Staff have prepared a detailed report for committee's consideration and recommend that the application be approved, subject to the standard conditions of consent. In light of the correspondence received from Trevor George on behalf of the benefiting lot owners at 7 and 9 Hiawatha Lane, the committee may wish to consider adjourning the application to allow time for the resolution of the private matters raised. Staff note that a revised consent sketch is required to be submitted prior to the circulation of the notice of decision to reflect the accurate lot lines and configuration of the retained lot. Staff have no further comments at this time and are happy to answer any questions from committee members.
Thank you very much, Ms. DeMello. Is the applicant or applicant's agent here wishing to speak on this? Yes, you can come forward, please. And please turn on the mic.
On.
Yes.
Good morning, staff. Good morning, council. This is Alex Forshoe with Forshoe Design Associates at 3 Lee Valley Drive, Port Carling, Ontario. I'm representing my applicant, my client, Blair Marsden. Thank you, staff, for your comments and your report and your recommending approval. I'm here to answer any questions. Thank you very much.
Good morning, Chair Edwards and committee and staff. Thanks for the time today to speak. I'm here speaking on behalf of the benefiting lots number 2 and 3 with respect to the application. You have received correspondence from Trevor, which was already noted, and I guess the key concern would be that if you could put the map back up. Yes, oh, sorry. I'm not looking at my notes. Box 255, Bell, Ontario, POC 1AO. Cheryl Mortimer, sorry, I thought I said that. Can I approach? So generally, I think the key concern with respect to benefiting lot 2 and 3 is this triangle here has been missed as highlighted in yellow, or should be highlighted in yellow, because it's part of the, according to our solicitor, it's part of the current right-of-way and should be continued. I think that is all we have to say right at this moment. Thank you very much for your time.
Sorry, anyone here wishing to speak in support of this application? Anyone wishing to speak in opposition to this application? Questions from the members? Yes.
Thank you, Chair Edward. Thank you, Chair Edwards. I think you have to help me understand exactly what the concern is here from Mr. Brown's or Mr. George's comment that the shading is not right. And so can somebody help me understand that? I'm trying to sort it through, but I'm not finding it very easy.
Okay. Yes. You can pull that up.
So, Zone, yeah. So I believe Mr. George's name, he was concerned with the pink or the magenta shading. And this is, and staff can correct me if I'm wrong, but this site sketch is just showing where the right-of-way is going to be moved, not that necessarily the pink is going to be extinguished, because that would also inhibit my client to gaining access to his own property. So it's not that that road is going to be extinguished. I think this is just for pictorial purposes of where the right-of-way is moving, the deeded right-of-way for the benefiting lands.
Could I? So what we're really saying is that your client is still going to have access from that road, but the right-of-way will be removed. The pink right-of-way will be removed over their land.
I believe this is just talking about 7 and 9 Hiawatha Lane.
No, but I want to understand the other part, if I might.
I believe that
the right-of-way is going to disappear, that pink right-of-way. Maybe I should be asking staff this question. I'm not sure, but that is going to disappear because the new right-of-way is going to be the yellow one.
The yellow one is the right-of-way for 7 and 9 Hiawatha.
Yeah.
There's still going to be deeded right-of-way to 1 Hiawatha, but they're not a benefiting land in this application.
So we have two right-of-ways going on here. This is why I'm a little confused. I'm really sorry. I'm a little confused about this.
Through your Chair Edwards, my understanding was that the portion of the existing right-of-way highlighted in purple was to be extinguished. That was my understanding.
That was mine, but now I'm hearing that's not the case.
I think the applicant's agent may be indicating that the road is to be maintained and the road will still exist leading to 3 Hiawatha Lane. But my understanding in corresponding with the applicant's agent was that the area in purple was to be extinguished.
Well, that makes sense to me. There's still a road and they can still get to their property, but it's not a right-of-way anymore?
Yes, go ahead, Mr. Sharp.
Through you, Chair, and good morning, everyone. And thank you, Ms. DeMello, for your answer. I can try to elaborate. As labeled on the consent sketch, it's indicated that that portion in pink or magenta is to be extinguished. That's largely a private matter between property owners. I'm not a lawyer, but it's my understanding that if there are legally established rights of way over that pink portion, those rights of way could not be removed without the consent of the benefiting landowners. So if benefiting lots number 1 and 2 have a legally established right-of-way over that magenta portion. In order for that right-of-way to be extinguished, as is indicated on the consent sketch, the written permission would be required, the written consent, and that would be something that would be worked out between the landowners. With respect to the little triangular portion that Ms. Mortimer had pointed out in her presentation to committee, that portion, it's our understanding, at least, that that portion forms part of what would be the retained lot in this particular application. It just so happened that it wasn't identified as such on the submitted consent sketch. So if a right-of-way were to be granted over that little triangular portion to the benefit of each of the benefiting lots, what could be required is just simply a revised consent sketch to indicate that that portion is in fact part of the retained lot, and that a right-of-way is proposed to be granted over those lands. And then that notice of decision could be attached to that consent sketch rather could be attached to committee's notice of decision. So hopefully that helps provide some clarification. Thank you.
Through you, Chair Edwards. Thank you. That was perfect, actually. Okay, so I think we just need to change the consent diagram for that triangle so that 7 and 9 are guaranteed a right of way into their property. I think that's what I'm hearing. If the applicant is okay with that.
Yes.
Thumbs up.
Okay. Any other questions or comments? Yes.
Thank you, Chair Edwards. I have a question with respect to the letter, which makes reference to 1 Hiawatha Lane and his concerns over his ability to access his property, or his. Can somebody show me where 1 Hiawatha Lane is? Is it on that? It doesn't seem to be on that diagram. I see 9, 7, 5, and 3.
Through you, Chair Edwards, 1 Hiawatha Lane is located south of 3 Hiawatha Lane. It's not shown on the consent sketch, but it is located south of number 3.
So that individual's concerns over his right of access as expressed in his email, that those have been addressed?
Yes, he's not in agreement with the extinguishment of the existing right-of-way because he uses that portion of the right-of-way to access his property. So if he's not in agreement with extinguishing that portion, then that wouldn't be completed because he requires that portion of the right-of-way for access.
Okay, and that, as has been said, is a private matter. Is there any need or desire or ability to enshrine that anywhere, or is that's enshrined as you just expressed? There's no need to. There's no other step that could be taken to guarantee this individual his access that he's looking for.
Through you, Chair Edwards, no, I don't believe so. No, that's a private matter and they don't require consent from the township to extinguish a portion of the right-of-way, so that's all just dealt with privately.
Okay, thank you.
Yes, Mr. Sharp.
Thank you. I just wanted to provide a couple points of clarification. If that landowner has concerns about access to that specific property, they should really speak with a lawyer who's experienced in municipal and real estate law to confirm whether in fact they do have a right-of-way over that portion of the property that's in question. And if they don't, then they would need to work with that landowner in order to apply to the Committee of Adjustment for consent for a right-of-way. And again, just to reiterate, if there is a legally established right-of-way in favor over that magenta portion, it's our understanding that that could not be removed without the written consent. So there is a protection there. Thank you.
Thank you very much for clarifying. Yes.
I'm just confused about this letter from Trevor George that suggests that things get deferred. Like, doesn't it say here that there's going to be confusion and that while we appreciate some things are private, it's imprudent to forge ahead without having a firm agreement in place as to what will be acceptable to all? Who is writing that? And That is sort of the letter that I read from, sorry. The bottom keeps getting cut off of this letter, but anyway, the letter that was in the package.
Yeah.
I believe that person was from, Guy Wilson was from Unit 1, and they're not happy. So why are we not deferring this and letting them sort it out and then come back and have it clearer as to where everybody goes to get to their cottage?
Would somebody like, yes, just a minute. No,
We just had
let
that.
Mr. Sharp, it's committee.
Thank you, Chair. Just to reiterate Ms. DeMello's comment, certainly one option would be to defer the application to allow certain considerations noted within Mr. George's letter to be addressed, if that is what committee would like to see. In regard to that, Ms. Mortimer was here, and it's my understanding that she was representing the two benefiting landowners. And it seemed to me like at this point, perhaps the point that needs to be clarified is just essentially that there's a right of way proposed over that triangular portion. There was no mention of the other items, so perhaps those have been addressed over the weekend. But perhaps it'd be best to hear from Ms. Mortimer with respect to that. Thank you.
Would you like to answer that, Ms. Mortimer?
Hello again. The solicitor submitted the correspondence on Friday. We understand that he's recommended or suggested a delay. And if, I'm not a solicitor, I'm just here to speak on behalf of the applicants because solicitor was not able to be here. I think that what I said before was the key concern was the inclusion of that triangle, because if it wasn't included in the right of way, then they wouldn't be able to access their properties. I understand that there is a lot of other matters happening between the parties. And I understand that I guess they are private matters that don't fall to part of the right of way application. So it's up to the will of committee at this point in time, I would suggest.
Thank you. Yes, Member Bridgman.
Thank you, Chair Edwards. Ms. Grogan Green, I think that's the answer. Because that's a private matter. I don't believe this committee can hold this up for something that's a private matter that doesn't involve us. And I believe that I'm correct in my thinking on that. Maybe Mr. Sharp, you can reconfirm that?
No, I think you're correct, Member Bridgman.
Any other? Yes.
Thank you, Chair. So further to that, then, the comment about the individual at number 1 contacting a lawyer, that has been established a private matter. Will approving this application at this time have any negative impact on that individual's ability to do that, or will they just do that retroactively and deal with it as a quote unquote private matter?
Through you, Chair Edwards, to put it simply, what this application is proposing and the extent of committee's involvement is to grant a new right-of-way over the portion of road that's identified in yellow. I think extinguishing any rights of way, that's a private matter between landowners and their solicitors and the advice from solicitors. So that would be the extent of my comments. Thank you.
Thank you. Appreciate that.
Any other questions or comments? Okay. No. We didn't see. No, we wanted to defer. So. Oh. Yes, Mr. Sharp.
Thank you for indulging me. With respect to the amended consent sketch, just to indicate that triangular portion in yellow, I just wanted to point it out to the applicant's agent that we will need that consent sketch quickly after today's meeting, just to make sure that we can update the notice of decision and include that sketch within the notice of decision. There's some timing with respect to the Planning Act
Right.
circulating that, so I just wanted to make that comment.
I'm sure you can look after that right away. Right. Moved by member Brown, second by member Stokes, be it resolved that consent be granted for application B 17/18/19/25 ML, providing the following conditions are fulfilled. 1, a satisfactory registrable description deed of the separate lots right of way, together with any required right of way or easements, be submitted to the township along with a registered copy of a reference plan. 2, the confirmation be received that the township is satisfied that the retained lot is satisfactory for on-site sewage disposal, that any problems identified with any existing sewage system be corrected to the satisfaction of the township. Any questions or comments? All those in favor? That's carried. And the next application is A 2225 ML FITZPATRICK. That is Ms. Beamish.
Thank you, Chair Edwards. The next application to be heard is, sorry, just one moment. Consent application B 2225 ML in the name of Fitzpatrick. And I will be presenting this on behalf of Zoe Beamish. The retained lot is known municipally as 1023 Milford Manor Road, Unit Number 4. I would direct committee's attention to the consent sketch on page 45 of the agenda package. The purpose and effect of the application is to create a right-of-way over part of an existing private road in favor of the abutting property. Notice of this public hearing under the Planning Act was originally circulated 18 days in advance of this meeting. Notice of this application was recirculated 15 days in advance of this meeting as the application was revised to extend the aerial extent of the proposed right-of-way. The additional portion was indicated on the revised consent sketch included as part of the revised notice. 5 comments have been received to date. Comments were received from Nick Snyder, the township's chief building official, and planning staff from the district of Muskoka, both stating no objection to the application. Comments were also received from Doug Holland, the township's fire prevention officer, stating no objection to the application and providing fire response times. Comments were also received from Matt Beach, the township's development and transportation engineering coordinator, stating if approved, civic addressing changes may be required, and if required, address changes should be completed at no cost to the township and to the satisfaction of the township's operational services department. Comments were also submitted by George Brown, an area property owner, mentioning their concerns with the use of the township road allowance to the north, potential drainage issues, among other items. This letter has been circulated to committee. Staff have prepared a detailed report for committee's consideration and have recommended that the application be approved subject to the standard conditions of consent. Staff have no further comments at this time, but are happy to answer any questions from committee. Thank you.
Thank you very much. Is the applicant or applicant's agent here wishing to speak on this?
Yes, thank you, Chair Edwards. Stephen Fauner, Northern Vision Planning Limited, 109 Meadow Heights Drive, Bracebridge, Ontario, P1L1A4. I'm here representing Robert and Unag Fitzpatrick in this particular application. This one might look familiar because we did a very similar application that benefited 2 lots to the northwest in the name of Zwart, and that was approved by this committee in January 2024. So I have a PowerPoint presentation. I will go through it quickly. Again, some of these matters are similar than they were before. So So the reason for doing it is there is a current right-of-way that divides a waterfront portion of the Fitzpatrick lands from the main area, and they would like to make a more, how should I say, formal connection without it being crossed by a right-of-way and crossed by traffic, etc. Next. There is a new road that has been created along the north side of the property, and that's realistically what the Zwarts and now the Kibblewhites, that's really what they use to access their property. It's beyond any area that was impacted by the site alteration bylaw. Next. So this is an overview of the entire retained lands, and you can see the proposed right-of-way there. Next. And this is just closing in on that. And you can see down in the bottom left-hand corner how a portion of the retained lot does go out to Lake Muskoka, and that's the portion that they would like to have sort of unimpeded access, if you will. There a little section in the northeast corner was found to be required in this particular case over the, I'll call it the old right-of-way, and was needed in this case, but was not needed in the Zwart application. Next. This is the current sort of travel pattern of, I say current, I guess prior to the new road being constructed. This is the old travel pattern, I guess, for the northwesterly properties of Kibblewhites and Zwarts. And of course, that goes and splits my client's property, and that's what he's trying to rectify in this case. Next. And this is a picture of the rear of the existing dwelling on the Fitzpatrick property. Next. And this is the front of it. This is from the private road that divides the two, I'll call it the two parcels. Next. And this is looking down towards their waterfront parcel that has existing shoreline development on it. Next. And this is the road that goes between. So the dwelling here is on the right, and the boathouse and waterfront portion are on the left. Next. And this is showing a portion of the new road from the northeast corner looking west. Next. And this is at the other end of the new road looking back towards where we were. Next. And this is the one that we're looking back from the other side. This is at the northwest corner of the property. This is looking towards the east. Next. This is in behind the Zwart property. The Zwart property is on the left. Next. And this is where Zwart enters their one property to the left, and Kibblewhite is just behind me a bit and to the left. Next. And this is the Kibblewhite property. You can see the small red fence there. Next. And this is Kibblewhites as identified by their sign and 911 sign. It's Unit 7. Next. So this area is designated as community in the official plans. There's really very little policy on rights of way, and they're generally considered private matters. So no new lots are being created here. Next. And there's really very little in the comprehensive zoning bylaw. The existing legal right-of-way that the Kibblewhites have actually goes up to the north from the northwest corner of the Fitzpatrick lands. And a road there doesn't exist. And this was verified by Melissa Cope. And there's no right-of-way shown on the deed to the Fitzpatrick property. So this whole application will clarify matters for both parties. Next. And it'll ensure long-term access to Unit 7. Next. And it'll enhance the enjoyment of the Fitzpatrick property, and so that they won't be as interrupted by traffic between the two parcels. Next. And a previous application, Zwart, was approved January 2024, essentially doing the same thing as what we're doing here today. And that has been finalized. A certificate of consent has been issued by the municipality. Next. So in conclusion, in my opinion, it conforms to both the official plans of the township and the district OP. The current rights of way, it's certainly not clear on title, and this will formalize the rights of way. Next. And the laneway does exist, and again, will provide increased safety and security for those people who are using the FITZPATRICK property and reduce liabilities for everyone. So thank you, and I'm here to answer any questions.
Thank you very much, Mr. Fauna. Right on time. Thank you. Is there anyone else who wishing to speak in support of this application? Anyone wishing to speak in opposition to this application?
Yes.
Okay, bringing them in. Thank you.
Good morning, committee. Good morning. My name is George Brown. I'm a resident at Unit 1 on 1023 Milford Manor Road. I'd like to thank the chair for giving me the opportunity to speak. Yes, so I just, first of all, I just wanted to make a number of observation comments and questions. At the original or the first committee meeting, that being on January the 2024, the the map that was presented excluded a public road that labeled as 0377 on the map that I presented. So that the map that I presented in my application or submission to this committee, that I believe that road was created for the benefit of the residents on 1023 Milford Manor Road, probably for safety reasons. And I encourage this committee to research the reason for the bylaw or the reason for that road, that public road being created. And it has been actively used since its creation by my neighbors. So subsequent to the last meeting in January 2024, I also presented a concern about water on behalf of Mrs. Ray Savage-Arvey. The water on the north side of this new road tends to flow perpendicular to the road itself, right? And so as a consequence, the water coalesces at the foot of the road. Anyways, so just the one thing that I left with the previous meeting was that I was under the impression that this new road was a replacement or a substitute for the existing public access road, right? So I started using this road to walk and to visit several of my neighbors in that area. So the lawyer present indicated that there's only 2 residents there. There's actually 3 residents or 4 residents that are actually impacted by this new road or right of way. So my concern is that the information that was provided originally for this this new right of way, it wasn't complete or there wasn't full disclosure provided to the committee at that time, right? Subsequent to that, Mr. Fitzpatrick has indicated that I'm not allowed to use this new right of way to visit my 4 neighbors or 3 neighbors in the area. So I've been using the public right of way that's to the north of this road. And what I'm finding is that access is increasingly more difficult due to both the water, the water buildup, especially this last spring, as well the Milford Bay Golf Course, which butts parallel to this road. They've tended to alter the access to this road with boulders, farm equipment, and on occasion they put things like lumber and stuff on this road. So my concern is the public road was originally created for the safety of all the residents on 1023, whether it be a natural hazard or what have you.
Excuse me, you have 30 seconds left. Can you wrap it up, please?
Sure. So I just wanted to draw those concerns to your to you and to ask that you consider asking for flood mitigation or redirection of the a topographical map in order to ensure that there's free and unfettered access to the public road that previously existed parallel and butting against this new right-of-way. Thank you.
Thank you very much. Is there anyone else here wishing to speak in opposition to this application? Questions from the members? Okay, go ahead, Member Stokes. Okay, go ahead, Member Bridgman.
Well, I have to confess that I was confused again on this one. So it's my day to get educated, I think. I think that Mr. Fauner would like to do his rebuttal. Does he not have that?
Yes, we
available?
can. Go ahead.
Yes, thank you, Chair Edwards. Yes, I would like to respond in a couple of things. Certainly when the original proposal or first proposal last year was brought through, there was never any indication this was replacing a public road. This is private property. It's a private road. The other is I'm a little puzzled because I showed a picture in my presentation of the new road looking east. And if there was a road parallel to this, it certainly would have been evident to the left of the new road. And there's no road there that I can see in the photograph. If there's been drainage problems that have affected the so-called public road, I would have thought my client would have received a letter from the township indicating problems. And we haven't received any proof from Mr. Brown that there's a public road that exists there. To me, it's hearsay. He's giving his own opinion, but we've received no legal matters or legal letters, if you will. Mr. Fitzpatrick is using Melissa Cope, a well-known lawyer in Port Carling, and she has researched the other properties that are going to be using this road. And Mr. Brown's property is not one of those. We've identified Mr. Zwart, who has 2 properties, the Kibblewhites, who have 1 property, and there is another property immediately to the northwest of the waterfront parcel. And I forget the gentleman's last name. His first name is Farhard. And those are the only ones that are entitled to go across this road. And again, it is not replacing a public road. This is a private matter, and we're just going on the basis partially that, of course, the previous 2 were approved for Zwart in the same manner. And this is for the next property immediately to the south of Zwart's to receive basically the same approvals, and so that we get clarification of those particular rights of way. But it's by no means replacing a public road. And to my knowledge, we've not received anything from the township indicating anything regarding drainage problems regarding that road. I don't know presumably if it's a township road, it would presumably have a name. I don't believe it has a name. So anyways, those are my comments. Thank you.
Yes, Member Bridgman.
Thank you, Chair Edwards. I think I'm going to start with, when I went on GeoHub, I was really trying hard to figure this out the other day. It looks to me like the township had a right-of-way to the water, where we're now talking about this private road, which I think is designated, because I drove down to the corner the other day, and it looks to me like it splits 1023 and 1021. Is that the private road? Like, I am really confused. I'm sorry, but I don't quite understand. And if there was a right of way to the water, then how did it become a private road now? I don't quite understand any of it.
Would like to take that one.
Good morning, committee, and just for the formalities, for those watching, I'm the township's manager of planning. I'm just going to take committee through the details of this particular application. If we could perhaps just move that up so that more of the property is shown on the screen. Perfect. And could we maybe start with the GeoHub map? Great, thank you. So down here, you'll see the retain lot. So that's the applicant's property. And this is Milford Bay Road, a public road. And Milford Manor Road, part of it is a public road. It follows a road allowance and it terminates at this location here. This part that you're seeing in white, it's my understanding that that is a township road allowance that leads to water. There is a private road over part of the road allowance. However, the portion that traverses the road allowance terminates at this point here where it enters the applicant's property. The new right-of-way has been installed along the lot line abutting the township road allowance, and that is one of the portions over which a right-of-way is proposed. And there's also a road that comes down to the south, and a right-of-way is proposed over that portion as well. Perhaps if we could go to the consent sketch. Perfect. Okay, so again, this is part of the road allowance that I was showing on the GeoHub map. It's up in this location here, and then it comes down in this direction and then up and over. The proposed right-of-way is outlined in yellow. It follows that northerly lot line, and then it comes down, and the proposed right-of-way is intended to benefit this property here. So I know it's a little hard to follow, but I'm happy to elaborate if needed, and perhaps Mr. Fauner could chime in too if he thinks that that would be helpful. Thank you.
Chair Edwards, thank you. But there's a road there right now. That's part of why I'm confused. You know, the road allowance that you talked about, and then we're going to give the right of way below that road allowance. There's an actual road there. So how, if the township hasn't developed that road, who owns that road? I'm really confused. I'm sorry, Mr. Sharp.
Yeah.
Go back to the GeoHub. Yeah. Through you, Chair Edwards, to Member Bridgman, is the confusion surrounding this portion? Right. Yeah. Yeah, so there's been a, yeah, so there's
a split there.
right. So nothing is proposed to change with respect to this portion of the right of way. There's a small corner of this existing private road over which a right-of-way is intended to be granted in favor of the benefiting landowner. There's a new road that's been constructed that follows this northern lot line in this location. And that is where part of the right-of-way is proposed also. And then it extends south for a distance, and the right-of-way is proposed over that portion as well. Nothing is proposed to change with respect to this municipal road allowance that leads to water.
So I believe that's the answer to my question. That new road that has been constructed is actually on the applicant's property.
That is correct.
Thank you. That was where I was getting so confused.
Any other questions?
Well, that was very helpful because I didn't visit the area and I didn't, I was confused also. I guess my question just relates to the questions that were provided or asked by Mr. Brown in his letter. Have those questions been answered, or is that not something that we address? Because I think they're reasonable questions and there does seem to be a lot of confusion over this. At the bottom of the letter, he has 4 questions listed.
Bryce, can I? To you, Member Stokes, through Chair Edwards. I did respond to Mr. Brown's questions on Friday morning, I believe. I had indicated to him that that area he was referencing with those PIN numbers is actually a township road allowance and is not a township road or a publicly maintained road. So I did kind of respond in that manner. He did have some subsequent questions that I did not have the opportunity to respond to, but I'm certain that we could help him out with his additional questions. Thank you.
Thank you very much. Yes.
Just perhaps Chair Edwards, just for his benefit, the flooding and the water part is not part of our mandate. So I just would like him to understand that.
Any other questions or comments? Yes, Mr. Sharp, did you have your hand up?
Through you, Chair. Thank you. Just with respect to Member Bridgman's comment, I just wanted to reiterate that the Township's Operational Services Department, Public Works, has commented and hasn't raised any objections with respect to this application. And to my knowledge, they don't have any concerns with respect to flooding or drainage or anything in those regards. Thank you.
I'm going to let you speak, Mr. Fawner. This is the last time because it's gone to committee, but maybe you can straighten it out.
Well, I think, thank you very much, Mr. Chair, and thank you for your indulgence. I think we're more or less on the right track. I just want to make a couple of points. The survey has been completed for these WART applications, was done by Bunker Surveying out of Gravenhurst, and they've certainly identified this right-of-way as being entirely on my client's lands. We've also had the consent certificates also stamped by the municipality for those two, which is in essence the same, almost the same application as this. So again, it's entirely on private land. And yes, what is immediately to the north is a road allowance, but that doesn't necessarily constitute that it's a road. Thank you.
Nothing? Okay. Moved by Member Stokes, second by Member Bridgman. Be it resolved that consent be granted for application B 22/25 ML amended FITZPATRICK, provided the following conditions are fulfilled. 1, that a satisfactory registrable description deed of each severed lot right of way be submitted to the township, along with a registered copy of the reference plan. And 2, that confirmation be received that the township is satisfied that retained lot is satisfactory for on-site sewage disposal, that any problems identified with any existing sewage system be corrected to the satisfaction of the township. Any questions or comments? All those in favor? And that is carried.
Thank you very much. Have a great day.
Thank you. And the next application is 1825 O'Connor. That is Ms. DeMello.
Thank you, Chair Edwards. The next application to be heard is minor variance application A-1825 in the name of O'Connor and New. The subject lands are known municipally as 1013 Center Avenue. I would direct committee's attention to the submitted site plan on page 105 of the agenda package. The applicants propose to construct a new one-story dwelling. Notice of this public hearing under the Planning Act was circulated 16 days in advance of this meeting, and 22 comments have been received to date. Comments were provided from Nick Snyder, the Township's Chief Building Official, and Matt Veach, the Township's Development and Transportation Engineering Coordinator, stating no objection. Comments were also received from Douglas Holland, the Township's Fire Prevention Officer, stating no objection. 18 letters of support were received from residents in the area. One letter of objection was received from the abutting easterly property owner, outlining concerns pertaining to the proposed easterly side yard setback of the dwelling, concerns with impacts on stormwater management, vegetative buffering, and issues pertaining to trespassing owing to the proximity of the existing and proposed dwelling to the shared lot line. The proposed variances are summarized as shown on the screen. This table was included in the circulation materials and can be found in the agenda package. Staff have prepared a detailed report for committee's consideration and have recommended that the application be approved subject to the following conditions: that a minor variance agreement be entered into under section 45(9.1) of the Planning Act along with securities wherein the owner agrees to remove the existing shipping container, the temporary use of which is for storage of construction equipment and material prior to the issuance of final occupancy for the proposed dwelling or within 2 years from the date of committee's notice of decision, whichever occurs first. This agreement is to be registered on title. That the shipping container be relocated in compliance with an interior side yard setback requirement of 15 feet to the satisfaction of the township. That a wood shed not identified on the submitted site plan be removed or brought into zoning compliance as necessary. That a satisfactory stormwater management brief containing grading information and erosion and sediment control measures be prepared by a qualified professional and implemented to the satisfaction of the township. And that a satisfactory site plan agreement be entered into and registered on title along with any necessary securities to implement the stormwater management brief as necessary. Staff have no further comments at this time and are happy to answer any questions from committee.
Thank you very much. And is the applicant or applicant's agent?
Oh, thank you, Mr. Chair. Good morning, members of the committee and township staff. My name is Sam Soya. I'm a senior planner with Tulloch at 80 Main Street West in Huntsville, postal code P1H1W9, and I'm representing the applicants here today. I'd like to thank township staff for their review of the application and for their recommendation. As is detailed in my planning report, the applicants are looking to replace a legal non-complying dwelling on a narrow lot. In this case, the zoning bylaw would legally permit the reconstruction of the dwelling in its exact present location, along with some as-of-right minor additions. However, the proposed dwelling has been designed to include some important improvements to setbacks and to allow for modern construction standards when compared to the existing dwelling, which dates back to 1925. Because of the narrowness of this lot, with it only being 50 feet wide, every slight shift of the building envelope and every slight change to its shape does result in the need for variances from several setback requirements. The site plans that are on the screen are zoomed into the southerly portion of the property and show the existing dwelling with associated sun deck on the left and the proposed dwelling and sun deck on the right. And as can be seen, the changes include the establishment of an easterly side yard and an improvement to the front yard setback, while at the same time using only the existing disturbed area and avoiding the need to replace the existing sun deck, which was recently rebuilt. It's also important to note that while having some as of right development rights to construct a second story, the building has been designed to continue to be only a single story building, while at the same time not increasing lot coverage. These improvements are the result of extensive thought and design work to take into consideration the constraints of this of the property. I'd like to just quickly talk about the recommended conditions of approval, as we do have some suggestions. Firstly, there is one condition which requires the removal of a new wood rack, and the applicants have no concerns with this condition, and the structure will be removed. There are two other conditions related to a temporary storage container. This container is owned by the applicant's builder, Van Brothers Construction, and it's required for tool and materials storage and to enable an efficient, secure, and overall tidy work site, currently for the demo and the site prep, and then for the construction of the dwelling. Staff have recommended a great condition that involves entering into a minor variance agreement to permit the container to remain on the property for the construction period. While the applicants are very willing to enter into this agreement, the only concern is another condition which requires the container to be moved 15 feet from the side lot line. Again, due to the narrowness of this lot, moving the container 15 feet will result in it blocking the entire driveway. And given the slopes elsewhere on the property, there is no other suitable location for it. That being said, there is some room to make a significant improvement here. Currently, the container is only inches from the easterly lot line, and it could be moved out 4 feet and still allow for vehicles to access the site. I would therefore ask that the container be temporarily permitted 4 feet from the property line through the minor variance agreement. This would make it possible to retain the container, thereby supporting an efficient and orderly work site, which would be a benefit to the entire neighborhood and during construction especially, and then ensuring its removal thereafter. Then lastly, the conditions of approval as currently drafted require an engineer to prepare a stormwater management brief and grading plan, and for the brief and plan to be implemented through a site plan agreement. Having visited this property and having reviewed available elevation data, the flow of water is directly towards the lake. If there is any flow from one property to another at the location of this dwelling, it appears to be from the easterly neighboring property onto the subject property. And as the neighboring property is at a higher elevation, which is this elevation difference can be seen in figure 9 of the staff report. Also, there will be no change in lot coverage, so no increase in covered area. And the dwelling's footprint size is the same. The position is improving, and the building code requires building inspections to confirm that drainage will not in any way impact neighboring properties. So we would therefore ask committee to, in this case, weigh the added value of such stormwater management documents against the $6,000 to $10,000 cost, plus application fees for the agreement, and plus the multi-month delay that this would cause for a project that is ready to start today. Drainage and infiltration is going to be greatly improved through modern construction, and the applicant builder, Don from Van Brothers Construction, is here today. Should you have any questions about construction or about the drainage associated with that, I'm available to answer any questions, as are the applicants, Sean and Christine, and also Don from Van Brothers Construction. Thank you.
Great, thank you. Is there anybody else here wishing to speak in support of this application?
Morning, Mr. Chair. Thank you. Committee, thank you. Members, my name is Sean O'Connor. I'm the owner of 1013 Center Avenue in Bala. I reside in Bala. I work in Bala. We're a member of our community. We look forward to creating a dwelling where our kids and grandkids can enjoy for a lifetime. We appreciate your support today. We look forward to moving on. Thank you very much for your time.
Thank you. And is there anyone else wishing to speak in support of this application? Anyone who wishes to speak in opposition to this application? Okay, questions from the members? Yes, Member Bridgman.
Thank you, Chair Edwards. Could we just review why, just for the benefit of everybody, why we want a stormwater management report here, please?
Thank you, through you, Chair, and thank you for your question, Member Bridgman. Ms. DeMello is going to share the site plan. As Mr. Soya had correctly pointed out, the property does have many constraints in terms of, I'd say most notably, its deficient lot frontage. That means that the property is quite narrow. And you can see that there's not a whole lot of room between each side yard. We gave quite a bit of consideration to the condition, including reaching out to our colleagues in operational services or public works who have some engineering expertise. Typically, what can happen in a lot of cases during construction is some changes to drainage can occur as a result of the construction, grading, adding some fill here and there as it's required in compliance with all the township's requirements. I think we've looked at property photos quite closely. We have the benefit of having, I think, 3 site visits on the neighboring property to the east, and we have quite a log of photos going back several years with respect to that property. Plus, we've had the benefit of our own site visit on the property as well. And I think in part, the reason we've recommended stormwater management is just to provide some assurance going forward that the redevelopment of this dwelling won't cause any drainage issues onto the neighboring property in the future. And then, of course, I would note that, you know, the property or the redevelopment does require some relief, for example, from front yard setbacks. There are steep slopes over the front of the property, and in my opinion, I think it represents good planning to recommend the stormwater management. Thank you.
Anyone else? Yes, Member Stokes.
Thank you, Chair Edwards. This question with respect to a statement that's made on page 93 of the staff report, and how that relates to the plantings comment, which I believe is on page 89. It says, staff note that the lower deck portion of the existing sun deck has front yard setback of 15 feet. And then it says, which appears to be legal non-complying. So I guess the question is it non-complying or is it not non-complying? And if it's not non-complying, we say that because of the decks and because of the property itself, plantings can't be made. So if it is non-complying, would it be beneficial to adjust that somehow so that those plantings could be made?
Yes.
Through you, Chair. Thank you for your question, Member Stokes. I can answer the first. I think with respect to the notion of this deck being non-complying, I think it is, so far as we can tell, based on our extensive research that we've done into the property, legal non-complying. However, the proposed addition, of course, is as built or illegal, and that's why the variance is related to that structure in front of you today to attempt to legalize it. With respect to the plantings, Ms. DeMello has visited the property, and I'd look to her to provide some insight with respect to her comments about plantings. Thank you.
Through your Chair Edwards, due to the existing sun deck, the lower and upper portions that are located on the property, there didn't appear to be sufficient space to permit additional plantings. There's also some rock outcrops along the shoreline as well, which would appear to maybe prevent additional plantings along the shoreline.
Yes. Member Bridgman.
Thank you, Chair Edwards. To the applicant's request about the shipping container, and if it's moved to where we want it moved to, it's going to cover the driveway. Could we, what I would like planning committee's comments on moving it the 4 feet, so at least it's not on the property line? Or is there somewhere else? I just think we need to answer that. Thank you.
Through you, Chair, Ms. DeMello, could you perhaps share your screen, just the site plan, please? Thank you. I would note that the township's zoning bylaw does permit a recreational vehicle to be placed on a property for the purposes of storage, provided a building permit has been issued and provided that it's not, it's removed, I believe, from 60 days from that building permit being finalized. But the caveat is that the recreational vehicle needs to comply with all of the required zoning provisions. So in this particular instance, the storage container that's been placed on the property, it's not a recreational vehicle, so that it doesn't benefit from that provision, and it hasn't been placed in compliance with side yard setbacks. I think it does count towards lot coverage, and it's going to cause lot coverage to exceed what's been applied for, as we had indicated in our report. However, I think given we do see that the benefit of having, some interior storage on the property to keep a tidy and clean work site during construction, but I don't think I don't think that it should be placed in such a way that doesn't comply with side yard setbacks. I think the development on the property as it exists today is within side yard setbacks, and this will, if it's permitted to remain, will exacerbate that. My thinking is that the applicant will need to find a way in order to bring this storage container into compliance with the 15-foot side yard setback requirement. It may mean instead of it being orientated perpendicular to the side lot line, it may need to be parallel. And it may be, an inconvenience, but I'm sure my hope is that they can come up with something to make it work. But I am hesitant to just have a blanket permission, even on a temporary basis, for that storage container to be within the side yard setback. Thank you.
Yes.
I'm sorry, committee. I've got lots of questions today. So it is possible for them to move it and be in compliance. I think that was my original question, actually.
Well, my hope is that they can find a place on the property that complies with the side yard setback requirement. I'd perhaps look to Mr. Soya to provide his comments. He seems to think not, but like I say, I'm looking at it and I'm thinking, well, if we could reorientate it again so it's parallel to the side lot line, there may be an opportunity there. Otherwise, it may be that, at least from staff's perspective, that the storage container just won't be able to remain on the property. Thank you.
Okay, since it was directed to Mr. Soya, I will let Mr. Soya speak.
Thank you. Through you, Mr. Chair. The location of that storage container is it's been placed where it has been due to due to the slopes on the property, for one, and then the narrowness of that lot. When you get further down on the property, it starts sloping down and it's not conducive to placing a storage container. And the driveway is quite narrow there, and it's also a safety matter with regards to construction, to making sure that this container is in a spot where trucks and so forth can still enter and leave the site and turn around. And it's therefore placed in very far back from the water on the only real level area on this property. And therefore, we're proposing that we've looked at the site to see what we could do to place it, to keep it on the property so that it can be used to secure tools and store them and materials, and to keep an orderly job site there. So I think that's the reasoning that we would like to keep the container, but there is no, if you really
The site plan maybe doesn't do it much justice because you see a lot of space below that, but because of the slope, it's not possible. So we're hopeful that if this minor variance agreement is used to temporarily allow this additional lot coverage through the container, that it could also be used to implement a lesser side yard setback on a temporary basis, of course. Thank you.
Mr. Soy, I believe you said you could move it 4 feet from the lot line rather than the 15.
That's correct. Yeah. We could move it 4 feet and there could still be access past it and still keep a little bit of space for safety. Thank you.
Any other questions or comments?
Yeah, I mean, just with regards to drainage, Don from Van Construction is here as well. And he would be able to talk to the improvements that are being made for through compared to a 100-year-old building to a new building with meeting today's building standards, and drainage would be part of the requirements that need to be met at the footings inspection, and then also at final inspection to make sure there's absolutely no impacts on neighboring properties. That's built into the building code process. Thank you.
Okay. Mr. Sharp? Would the planning staff be agreeable to a 4-foot setback so that vehicles could get by for the construction?
Thank you, Chair. I think we're in your hands at this point. If that's something that committee would be comfortable with, it's within your purview to allow that to occur.
Well, it is sort of an improvement, but I haven't seen the site, so I don't know. If the planner could say that that's not acceptable, I would take it. Committee may look to that.
Through you, Chair, I think we've provided our insight with respect to this at this point. I think existing development is already located quite close to the side yards. I think we've heard concerns from the neighbor. I'm not sure specifically with respect to the storage container, but certainly with respect to the redevelopment. As I had noted, the zoning bylaw does contain some provisions for some temporary storage. Note specifically a recreational vehicle. The zoning bylaw would require such recreational vehicle to comply with all other requirements. The storage container already exceeds the lot coverage that's being proposed. So I think we've tried to come up with a solution that would work for the applicants. I just think that allowing the storage container on a temporary basis, even within the side yard, staff are uncomfortable with that. But again, it's within your hands. I would note if I think something that may have gotten lost in the conversation was Mr. Soya's request with respect to the conditions requiring the two different agreements. So we've recommended a minor variance agreement under Section 45 of the Planning Act to deal with the storage container specifically. But we've recommended a site plan agreement under Section 41 of the Planning Act to deal with the stormwater management component. Under Section 41 of the Planning Act, it allows us to deal with specific aspects as detailed in the Act, such as drainage and stormwater management. It doesn't deal specifically with something like an agreement allowing a structure to remain on a property for a temporary basis. And hence, that's why we've recommended that it be addressed through Section 45 of the Act through a minor variance agreement. With that being said, if the applicant and the applicant's agent are amenable to including such a provision in said site plan agreement, I don't think that staff would object to that. It would allow for a bit more of a streamlined process. And essentially, it would amount to a contractual agreement between the township and the applicant. So I don't think that we would object to that request if that's something that committee is interested in. Thank you.
Thank you, Mr. Chair. Well, it's a bit of a difficult question because essentially we're asking for consideration of the site plan agreement to require a stormwater management brief and grading plan. So we do not feel that that would be necessary, that would be handled through the building code process. And just with respect to the setback, it is in a level area, and I believe there is a picture in the staff report that shows the container, but it would be moved off of that lot line by the 4 feet. It's a level area. It's at the top of the hill. It's not causing a drainage problem in that location, this container. So it would be without that portion of it, the minor variance agreement would not be applied for, because that container will not be able to stay on that property because it would block the driveway. And that would be unfortunate for efficient construction. But yeah, I mean, if we're talking about reducing it from two agreements down to one, of course, that would be preferable. But if we're just entering into a minor variance agreement to allow there to be a storage container, then that would be the preferred approach. Thank you.
So, sorry.
I asked them to speak to you.
Thank you, Mr. Chair. Thank you, committee. I'd just like to bring this story into perspective to give you a little background. I spoke in front of this committee 10 years ago when the applicants on our adjacent at 1011 Center Avenue applied for a minor variance for their pergola over their property. I have the minor variance in question. During that, their backfill that they put around their sleeping cabin, all their sand fill, as they hadn't followed their site plan agreement, washed under onto our property and buried all our plumbing. When the Committee of Adjustment put the notice of hearing for the minor application in place, I had my opportunity to come and speak to council, provided pictures to show that they had not followed their site plan agreement. In my opinion, we're building our forever home. Why wouldn't we look at safeguarding our investment? I'm asking the township today, what you're hearing from our neighbors is probably a little payback to come back to us for this. We've fully engaged in our drainage management. We know that this is something very important to us. I have the reference in front of me, what the date was 10 years ago when I spoke to committee.
Well,
I need some more to be there.
That's history, but what we'll do is,
I appreciate your time.
okay, thank you.
Thank you very much.
Question?
Thanks. I actually was more concerned about the letter that we haven't addressed, which is related to the neighbor. And I do find it ironic that we're worried about a storage container 4 feet from the lot line when we're talking about a cottage that's going to be 2 feet from the lot line. I'm in favor of making sure that the storage container abides by side yard setbacks, number one. Number two, what about this letter? Does anybody from the committee want to discuss what is in it? They believe that there is room for vegetation, for example, in the side yard. So, and apparently when they applied for a minor variance 10 years ago, that was a requirement of theirs. So I think some of these things in this letter maybe should be discussed. When did the letter come in? Like, relative to when all of these decisions were made?
Staff answer that.
Through you, Chair Edwards, we received this letter on June 1st.
Okay. Good. I think what I'll do is I'm going to read the resolution. And we can go from there. Moved by member Bridgman, second by member Grogan Green. Be it resolved that minor variance application A 1825 O'Connor and New to demolish and construct a new one-story dwelling, construct it a new sun deck, landing, and stairs, and to recognize an as-built addition to an existing sun deck is hereby approved with the following variances being granted. 1, to permit a lot coverage of 1,376 square feet or 10% over the area of the entire lot. 2, permit a lot coverage of 1,376 square feet or 13.4% within 200 feet of the high water mark. 3, to permit a dwelling to be set back 35 feet at the closest point from the high water mark. 4, to permit a dwelling to be set back 1.9 feet at the closest point from the easterly interior side lot line. 5, to permit a dwelling to be set back 9.1 feet at the closest point from the westerly interior side lot line. 6, to permit a sun deck addition 1 to be set back 21.3 feet at the closest point from the high water mark. 7, to permit a sun deck addition 1 to be set back 7 feet at the closest point from the westerly interior side lot line. 8, to permit a sun deck addition 2, landing and stairs to be undersized on an undersized lot. 9, to permit a landing to be set back 10.8 feet at the closest point from the westerly interior side lot line. 10, to permit a sun deck addition 2 to be located 9.5 feet at the closest point from the easterly interior side lot line. 9, to permit a sun deck addition 2 to be located 32 feet from the closest point from the high water mark. And 12, to permit a sun deck addition 2 to be located 13 feet at the closest point from the westerly interior side lot line. These variants are granted as shown on the plan attached to the notice of decision and are subject to the following conditions. 1, that the minor variance agreement be entered into under subsection 45, 9.1, along with securities wherein the owner agrees to remove the existing shipping container, the temporary use for which is for storage of construction equipment and material prior to the issuance of a final occupancy for the proposed dwelling, or within 2 years from the date of the committee's notice of decision, whichever occurs first. This agreement is to be registered on title. Excuse me. 2, that the shipping container be located in compliance with interior side line setback requirements of 15 feet to the satisfaction of the township. 3, that a woodshed not identified on the subject site plan be removed or brought into zoning compliance as necessary. 4, that a satisfactory stormwater brief containing grading information and erosion and sediment control measures be prepared by a qualified professional and implemented to the satisfaction of the township. And 5, that a satisfactory site plan agreement be entered into and registered on title, along with any necessary securities to implement the stormwater management brief as necessary. This approval shall remain in effect for 3 years from the date of decision. Any questions or comments? Yes, Member Bridgman.
Sorry, Chair Edwards. I have been back through my links. I do not have the letter that Lisa is referring to. So it's not in the file as far as I can see. So I'm wondering if we could have a 10 or 15-minute recess right now, and I can get the letter and at least read it so that I know what
I
we're
think that would
talking
be a
about.
good idea. We'll take a brief recess. And as soon as we're ready, we'll start back because we have been going over. Thank you.
Thank you. So could somebody send me this letter?
Agenda.
This is it. I don't have it.
Click on view. Comments.
Like to call the meeting back to order. Oh, they're still downstairs. Okay, I'd like to call the meeting back to order. So I've read the resolution. And we're open for comments from the committee. Yes, Member Bridgman.
Thank you, Chair Edwards. Now that I've read this letter, I just want to comment on it for committees. The side yard setback is basically what's in our report. It's legal non-complying and they're making it better, but you can't force them to go 6 feet. So that one, the stormwater management plan, I am going to take the recommendation of our planning committee. I think we need to do that. I'm also going to go with planning with our staff in terms of the tree plantings. I don't think we need to look at that. And the trespassing, I believe, would be a private matter. So those are my comments for what they're worth. So maybe I can keep going. In terms of the storage unit, we don't have anything in the bylaw that applies to it, is what I think I'm hearing more than anything else. And I'm very sympathetic when you're creating a new place to have some place to store things, and the fact that it's going to be not permanent. Would never look at this if it was going to be permanent, but if they can move it to 4 feet, and I'm not sure what I heard, maybe we leave that as a separate minor variance, because then it'll fall under bylaw as opposed to the site plan if it doesn't get removed. I would prefer that. I know it doesn't streamline things, but it gives us direct access to get rid of it. And so that's where I would sit on it. I would take everything that is in our motion, except I would say 4 feet for the storage container. I would be willing to accept that because it's temporary.
I don't disagree with anything that Member Bridgman just said, and I don't think we should remove the stormwater management plan out of the resolution. I think that should remain because there does seem to be some disagreement here, and staff recommended it. So.
Yes, Mr. Sharp.
Thank you. Through your chair, I just wanted to clarify one point with respect to Member Bridgman's comment. I believe what Mr. Soya had indicated was that if committee is willing to allow the storage container to remain at a setback of 4 feet, we could certainly amend that condition to state that. But I think what he was also saying was that he would prefer just one agreement for the storage container to be dealt with through a provision in the site plan agreement versus 2 separate agreements. which are two separate processes. And I had indicated that staff would be amenable to that if that's something that committee would be interested in as well. Thank you.
To amend that, then, please. Thank you.
Okay, through you, Chair, I'm just going to read this amended resolution. Moved by Member Bridgman and seconded by Member Brown. Be it resolved that the resolution be amended to replace 15 feet in condition number 2 to 4 feet. And be it resolved that the resolution be amended to revise condition 5 by adding the following after the word necessary. And wherein the owner agrees to remove the existing shipping container, the temporary use of which is for storage of construction equipment and material prior to the issuance of final occupancy for the proposed dwelling or within 2 years from the date of committee's notice of decision, whichever comes first. This agreement is to be registered on title. Pardon me?
Be amended with the condition.
And further, be it resolved that condition number 1 be removed. Thank you.
And understand that. Any more questions or comments? Seeing none, all those in favor? That's carried. All right. Now adds the main motion as amended. Just saying that the motion he just read as amended.
The main motion is amended.
And now we vote on the main motion as amended. Thank you. Okay. Now we'll go to A 2125, Uncle Argyle, and ask Ms. Christ.
Thank you, Chair Edwards. The next application to be heard is minor variance application A 2125 in the name of Uncle Argyle, Inc. The subject lands are known municipally as 1291 Peninsula Road. I would direct committee's attention to the submitted site plan on page 140 of the agenda package. The purpose and effect of the application is to construct a dwelling addition. Notice of this public hearing under the Planning Act was circulated 19 days in advance of this meeting, and 3 comments have been received to date. Comments were received from Nick Snyder, the township's chief building official, stating no objection. Comments were received from Matt Veach, the township's development transportation engineering coordinator, stating no objection but that Peninsula Road is a road under the jurisdiction of the District of Muskoka, and the application should be circulated to the district for comment. And lastly, comments were received from Douglas Holland, the township's fire prevention officer, stating no objection, as well as the calculated fire response time, and recommending that the Fire Smart Homeowners Manual be consulted to understand how treatments to the property influence wildfire spread. The proposed variances are summarized as shown on the screen. This table was included in the circulation materials and can be found in the agenda package. Staff have prepared a detailed report for committee's consideration and have recommended that the application be approved subject to the following condition: that a satisfactory site plan agreement be entered into and registered on title, along with securities for the retention of existing vegetation and plantings to retain and revegetate the shoreline buffer. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Thank you very much. The applicant wish to speak on this?
Yeah, during Zoom, I can bring.
Hello, my name is Joe Earhart. I'm speaking on behalf of my client from Steenhoff Building Services Group in Port Carling, address 3680 Highway 118 West, Port Carling, POB 1J0. Just to let you know that a client and I are both on the call to answer any staff questions about the proposal. Thank you.
Thank you very much. Anyone else wishing to speak in support of this application? Anyone in opposition to this application? No. Questions from the members? Moved by member Grogan Green, second by member Brown, be it resolved that minor variance application A 2125 Uncle Argyle Inc. to construct a dwelling addition and to recognize an as-built propane tank as hereby approved with the following variance being granted. One, to permit a lot coverage of 3,478 square feet or 10.9 over the area of the entire lot. To permit a front yard setback to be 49 feet for an as-built propane tank. And 3, to permit a minimum side yard setback of the lot line abutting the street to be 11 feet from the as-built propane tank. These variances are granted as shown on the plan attached to the notice of decision. They are subject to the following conditions. 1, that an as-built shed not shown on submitted site plan be removed as intended. And 2, that a satisfactory site plan agreement be entered into and registered on title, along with securities for retention of existing vegetation and planting to retain and revegetate the shoreline buffer. This approval shall remain in effect from 3 years from the date of decision. Any questions or comments? All those in favor? That's carried. And the next one is A 2425. It's Mr. Mello.
Thank you, Chair Edwards. The next application to be heard is minor variance application A-2425 in the name of BLIDNER. The subject lands are known municipally as 1523 Fish Hatchery Road, unit number 11. I would direct committee's attention to the submitted site plan on page 105 of the agenda package. The applicants propose to construct a new 2-story dwelling. Notice of this public hearing under the Planning Act was circulated 25 days in advance of this meeting, and 5 comments have been received to date. Comments were received from Nick Snyder, the township's chief building official, stating no objection. Comments were received from Matt Veach, the township's development and transportation engineering coordinator, stating that the proposed access is via a private road. These roads are not required to be constructed or maintained in accordance with township road standards. The Public Works Department does not review this type of access, and road access for emergency services may be limited and/or unavailable via the proposed road access. Comments were also received from Douglas Holland, the township's fire prevention officer, stating no objection. Letters of support were received from 2 area residents, including the abutting neighbor to the south at 1523 Fish Hatchery Road, unit number 19. The proposed variances are summarized as shown on the screen. This table was included in the circulation materials and can be found in the agenda package. Staff have prepared a detailed report for committee's consideration and have recommended that the application be approved. Staff have no further comments at this time and are happy to answer any questions from committee.
Thank you very much. See applicant or applicant's agent wishing to speak on this?
Good morning, Mr. Chair, members of committee. My name is Ted Williams. I'm at 387 Muskoka Road 3 North, Huntsville, P1H1C2. I've reviewed the staff report and am in agreement with it. I have Mr. BLIDNER here, who is the owner of the property, on the line today, and I will answer any questions, and those that I struggle with, I'll defer to Mr. BLIDNER. Thank you.
Thank you very much. Is there anyone else wishing to speak in support of this application? Anyone in opposition? Nope. Okay, questions from the members? Seeing none. Excuse me. Moved by member Brown, second by member Stokes, be it resolved that minor variance application A 2425 Linder to construct a new two-story dwelling is hereby approved with the following variances being granted. One, to permit a lot coverage of 3,563 square feet or 8.3% over the entire lot, and two, to permit a rear yard setback to be 5 feet at the closest point for a dwelling. These variances are granted and shown on the plan attached to the notice of decision. This approval shall remain in effect for 3 years from the date of decision. Any questions or comments? All those in favor? That's carried.
Thank you.
And the next application is A 2525, that's Mr. Mello.
Thank you, Chair Edwards. The next application to be heard is minor variance application A-2525 in the name of RINAS and NIERMANN. The subject lands are known municipally as 1057 Whitings Road, unit number 23. I would direct committee's attention to the submitted site plan on page 185 of the agenda package. The applicants propose to construct a new swim dock, a new single-story boathouse connected to a land-based dwelling, and a dock. Notice of this public hearing under the Planning Act was circulated 24 days in advance of this meeting, and 3 comments have been received to date. Comments were received from Nick Snyder, the Township's Chief Building Official, and Matt Veach, the Township's Development and Transportation Engineering Coordinator, stating no objection. Comments were also received from Douglas Holland, the Township's Fire Prevention Officer, stating no objection. The proposed variances are summarized as shown on the screen. This table was included in the circulation materials and can be found in the agenda package. Staff have prepared a detailed report for committee's consideration and have recommended that the application be approved. Staff have no further comments at this time and are happy to answer any questions from committee.
Thank you very much. So applicant's agent, you wish to speak? Okay, turn the mic on, please.
Good morning, Murray Taylor from Taylor Docks in Port Severn. We are the agent for Mark and Petra RINAS. I also have Tammy with me here today. We have had quite an opportunity to walk this property and understand what they would like for the outcome. Tammy definitely has done all the drawings, so I think between the two of us, we should be able to answer any questions you have.
Get your address.
It's 2733 Hodgins Road, Port Severn,
And your postal code?
BO 268.
No, we're L0K1S0.
Oh, sorry. There was post office box.
Okay.
Home. Thank you.
Is there anyone else wishing to speak in support of this application? Anyone in opposition? No? Questions from the members? Yes.
Just one question for clarification, from the building division comment. Just the note, it says, please note a permit cannot be issued for any dock encroachment onto adjacent lands. I'm assuming that's just there as a general statement. It has nothing to do specifically with the application.
Through you, Chair Edwards, I believe there is a current dock on the property that encroaches on the easterly lot, and that's not proposed to be reconstructed.
So in that event, sorry if I'm being pedantic here, but will the permit be issued for this hawk?
Through you, Chair Edwards, yes. Yeah, it can be.
Okay, thanks.
Any other questions or comments? Moved by member Stokes, second by member Bridgman, be it resolved the minor variance application A 2525 RINAS to construct a new single-story boathouse and attached dock is hereby approved with the following variance being granted: one, permit an easterly side lot line to be 10 feet at the closest point for a single-story boathouse with a rooftop sun deck, and two, to permit an easterly side yard setback to be 10 feet at the closest point for a dock. These variants are granted as shown on the plan attached to the notice of decision. This approval shall remain in effect for 3 years from the date of decision. Any questions or comments? All those in favor? That's carried. Thank you. And the next application is A2925.
Thank you, Chair Edwards. The next application to be heard is minor variance application A2925 in the name of Simonev, and I will be presenting this on behalf of Zoe Beamish. The subject lands are known municipally as 1158 Shea Road, unit number 37. I would direct committee's attention to the submitted site plan on page 208 of the agenda package. The purpose and effect of the application is to construct a dwelling addition. Notice of this public hearing under the Planning Act was circulated 19 days in advance of this meeting, and 4 comments have been received to date. Comments were received from Nick Snyder, the township's chief building official, stating no objection, and to please note that sewage system capacity will be reviewed upon submission of building permit applications and improvements may be required. Comments were received from Matt Beach, the township's development and transportation engineering coordinator, stating no objection. Comments were also received from Douglas Holland, the township's fire prevention officer, stating no objection, as well as the calculated fire response time and recommending that the Fire Smart Homeowners Manual be consulted to understand how treatments to the property influence wildfire spread. Lastly, a letter of support was received from Mark Holm and Jane Jones, area property owners, stating that they have no objection to the application, but noting some concerns around the existing sleeping cabin and septic system. This letter has been circulated to committee. The proposed variances are summarized as shown on the screen. This table was included in the circulation materials and can be found in the agenda package. Staff have prepared a detailed report for committee's consideration and have recommended that the application be approved, subject to the following condition: that a satisfactory site plan agreement be entered into and registered on title, along with securities to address the enhanced protection policies of the District of Muskoka official plan as necessary, and for the retention of existing vegetation and plantings to retain and revegetate the shoreline buffer. Staff have no further comments at this time and are happy to answer any questions from committee. Thank you.
Thank you very much. The application wishes to speak on this.
During Zoom, not responding, so
No.
the agent is in Zoom, but not responding. He's declined the promotion, so he has declined to join, so you can probably proceed. That's okay.
Are there any questions?
I have a question for you. Just to confirm, with respect to the comment from the building division about it references specifically system capacity will be reviewed with respect to the sewage. And I just want to understand that covers the comments in the letters from, the letter from Hallman Jones. They make reference there to, I believe, to capacity. And they also make reference to the existing septic system must be replaced in its entirety. I guess that's something that will be determined at the same time as that evaluation is done. I'm assuming that's the case. I just wanted to confirm that.
Yes.
Through you, Chair Edwards. I believe that would be the case. However, I do have Nick Snyder online, so perhaps he could further comment on that.
Would you like to bring Mr. Snyder in then?
My concern was a sleeping cabin, that it gets looked at. If there was no building permit, but there's plumbing in there, then will they look at that too?
Okay.
Thank you, and sorry, it just took a moment to connect. I'm not aware of the letters received from, forgive me, Hallman Jones, I think it was. But through any application for new construction, our process would be to ensure that the existing system is satisfactory to support the new development, or that application is made to support all development on the property. So I hope that answers the question.
I think we have another question from Member Bridgman.
So, Mr. Snyder, I just, this letter that came in mentioned a sleeping cabin that they believe plumbing has been put into, but it may have been without a building permit. So the question I would have is, do you have the ability to go in and look at that if all they're looking at is the main building? Or does that have to go through bylaw?
Thank you, and through you, Chair. If through the application process, it's determined that there was a building constructed without permit and without, or including plumbing, pardon me, we would have the ability to address that as well and ensure that compliance is achieved. Compliance could look like many different things. It may necessitate a permit be issued for the plumbing at the very least, or the building in its entirety. But we would review that through the application process.
Thank you, Mr. Snyder. Any other questions or comments? Saying none. Moved by Member Bridgman, second by Member Grogan Green, be it resolved that minor variance application A2925 Smirnoff to construct a dwelling addition is hereby approved with the following variance being granted. One, to permit a lot coverage 1,653.5 square feet or 8.7% over the entire area of the entire lot. To permit a lot coverage of 1,653.5 square feet or 8.8% over the lot, over the area within the lot within 200 feet of high water mark. 3, to permit a dwelling addition to be 9.5 feet as the closest point from the easterly interior side lot line. These variants are granted as shown on the plan attached to the decision and are subject to the following condition. 1, that a satisfactory site plan agreement be entered into and registered on title, along with securities to address the enhanced protection policies of the Muskoka's official plan as necessary, and for the retention of existing vegetation and plantings to retain and revegetate the shoreline buffer. This approval shall remain in effect for 3 years from the date of decision. Any questions or comments? All those in favor? That is carried.
Okay.
And, Mr. Sharp, did you want to go over the new business for the, oh. Okay. That's for the Ontario Committee of Adjustment Conference.
Thank you, Chair Edwards. Yeah, I just thought it would be helpful to maybe talk about some of the things that we learned at the conference. And I'm going to bring up a topic that I know has been discussed a lot, and it's in our bylaws, but it's not having the ability to go to a property and look at it, because today to me was a perfect example of how helpful that would have been. And there are other municipalities that do it. So it is not like it's not allowed. It's just that it's not allowed here in the township. So I don't know where we go with that, or if anybody else feels the same about that. I think I know how the staff feel, but if we would really like to do that, I don't know if there's an avenue to bring that forward, to have council look at it again, if there's support for that. That was one thing. If we want to stay with just the first one.
Yes.
Yes, I would really like to go back to site visits, and I'm very comfortable going by myself, and I will just drive very carefully.
I agree. I would love to be able to do a site visit as well. And I think too, there are lots of sites available that we can access online, but seeing it in person and 3D would be helpful. I guess I'm curious to know why we're not allowed to, because I was never part of that.
Well, one of the things is you can't visit all properties because there's islands and everything else. They'd have to supply a boat and everything, and that's one thing. Secondly, the mileage would be astronomical if you're driving around. And that's one of the things. If you have a concern about a property, if you happen to be driving by it, that's fine. It's not a thing. It's not actually a site visit. I know at Callan at one time when they were talking about site visits, they wanted to wear safety boots, a hard hat, a vest, and everything else like that because they're going on as somebody else. I've done it both ways. We used to go as a group in the car. We did not talk about the applications, but at least what they used to say is if one person goes, they all should go. So this is one of the things, but it's up to the township, I guess. And now, Mr. Sharp, how do you feel about it?
Thank you, Chair. Speaking off the cuff here, I didn't prepare in advance because I didn't quite know what the conversation was going to be, but I believe it wasn't too long ago that this matter was raised for committee and staff's consideration. Staff researched the topic, evaluated the options, and I believe that the committee's procedural bylaw was updated to indicate that visits by Committee of Adjustment members aren't intended to occur. And I think in part, I think one of the main reasons for that was just liability considerations. When an applicant files an application with the township, they're signing off that that staff can enter onto the property, and the planning division has quite a rigorous health and safety protocol that we follow. For example, when planners are undertaking their site visits, they're advising me of a list of properties that they're visiting. They're checking in when they arrive and after they leave each property. In some cases, they're even being accompanied by others. They're in cell phone contact all the time. So there's quite a bit to consider. Some of these properties are quite remote. It may be that the owners weren't expecting our presence on the property, in any given day. So there's conversations to be had around that as well. So yeah, there is a history. If we were looking to reconsider, I'm not sure that we would have a different answer than we had previously. Unfortunately, at this time, I think we pride ourselves on trying to provide a good suite of photos for committee to review and to assist in their understanding. If there's anything that we could do in that regard to improve, we're certainly happy to consider those comments. Thank you.
Anything else?
Well, I have to admit, Mr. Sharp, thank you for today. If you guys are willing to have me confused and answer all my questions in every meeting, that's really helpful.
I wonder if we could take a video of some of these properties rather than like still pictures. Would that help the committee? We could try something like that if it was a tough one. Just a thought, because like I say, for somebody who has traveled around to properties over the years, I find it helpful. But on the other hand, with the remoteness up here and everything else like that, that's one of the reasons why I agreed to it at the time, to let staff do it. They do a good job taking pictures and that. But Mr. Sharp, what do you think of that?
Through you, Chair, certainly, you know, I know that we are taking videos on occasion, and those are being used, you know, to assist our understanding for those of us that don't get out to the properties, such as myself. We'd be happy to consider how best to do that in a public hearing format. I don't know whether it would be something that you'd want for every property, if there were certain considerations where you feel that level of detail is necessitated, such as, for example, say a side yard setback or something like that. But certainly, you know, maybe that staff can look at ways to do that, and we can try and incorporate that into our reporting back to committee, be it in written reports. You know, maybe there's a link or something that we could do through that way, or alternatively in person in a hybrid format here. We could consider how best to do that. I just wanted to reiterate that there's nothing preventing members of Committee of Adjustment from viewing a property from a public location, such as you know, a water body that's accessible by the public, or from a public road. Thank you.
Anything else?
Yes, I recall that one of the big reasons was health, because it was during COVID, I think. Might have been after COVID that no, maybe not. I just think that it's in a person's fiduciary, like it is the fiduciary responsibility where you can to go to a site and check it out. I think it would avoid, for example, today, a couple of questions, even for consents that came up, that would have been much clearer if we were able to go and see. I did have a couple of situations where I took my car and I turned around because I didn't feel safe, but I did make that decision on my own, and I've never felt uncomfortable anywhere. I read the rules that you're not supposed to speak to the owner of the property. You're supposed to have a badge, identify yourself, not discuss the variances either with neighbors or the applicant. And I always found it satisfactory and useful. And I also think that, you know, the whole point of some of getting to a site sometimes is really coming to an understanding of how the neighbors may or may not react to an application. And it's easier when you can see it than to take, oh, this is a view here, the cottage is on this side, the lake's on the other. Like, just getting a chance to eyeball it is, to me, much better. I think it would avoid a lot of questions, and it's helpful. That's it.
Yes, Mr. Sharp.
Thank you, Chair Edwards. Appreciate the comments. The other thing I would just mention is that Committee of Adjustment is a quasi-judicial body, meaning that you're not intended to have, individual members aren't intended to have or be privy to information that others aren't. And a site visit may introduce concerns around that regard, or at least perhaps the perception that there may have been, you know, discussions that occurred on site, for example, with the property owner about their specific proposal. So I think that there's things that need to be considered in that regard as well. And I think that factored into our decision when this was raised. Not too long ago, I looked to Ms. Ward if she could confirm when the the procedural bylaw was amended, but I don't think it was too far in the distant past. Thank you.
Through you, Chair Edwards, the procedural bylaw for Committee of Adjustment was amended back in 2023.
And that was my understanding, Mr. Sharp, that basically being a quasi judicial body, it should be one, everybody should go or nobody should go. That was my understanding over the years. And that as well. This is why when I was in Calvin, we went as a group. We did not discuss it. I know this is what they say with the other, but I know, and it's probably more up here, but I used to put 170 kilometers on just doing a tour in the morning, sometimes it'd be 4 or 5 hours. So, I mean, there are things in that, like I say, I like the idea of seeing a site, but on the other hand, I do realize there's limits to it and that.
I got the impression at the conference that, to what Member Grogan Green was saying, that by not doing site visits, we're not fulfilling our full obligation to the applicants and that, but maybe I don't know. I guess I don't understand how some municipalities or most municipalities are doing it, but we're not entitled. And I think it's funny, we're really asking to give more work to ourselves by doing this, but just for a better understanding of things. So I guess I'm just not clear why we're saying, you know, why our township doesn't do it, but why other townships we're kind of shocked that we didn't do it.
For sure.
Through you, Chair. I can't speak to what other municipalities are doing relative to us. It may be that those other municipalities aren't doing it as well as us or not doing what they should be doing. But it may be that in 2023, we had done quite a detailed staff report with respect to this matter. And we had brought it forward to Committee of Adjustment for consideration as part of the procedural bylaw. Maybe that Ms. Ward could forward that to the members. You could review it. And if we want to continue the conversation, perhaps at the next meeting, if there's further questions based on that. But I think a lot of the detail that we're discussing today is in that report.
If we're going to discuss it again, what you should do is take today's agenda, figure out what the kilometers would be to drive around to see them all. Because I know driving around Ward B, putting signs up initially, I put over 250 kilometers on and I didn't get around. So if you have them in Valley, you have them in that, the cost would be staggering. It would be great, but and if there's something you think that is really controversial, you can always drive by it on your way somewhere. And that. Yeah, no, it's good. I'm in total agreement with it. I think it's nice to see it, but I think there was one time, I think you went with us, Bryce, that I took my boat and we went up and viewed one, and that we deferred it. If there's something really special, we could defer it and then go and see that particular property, even if we had to. But rather than doing them all, I don't know. It's just a suggestion. I'm up to what the committee would like.
Through you, Chair. I'm sure there's exceptional circumstances that we could try to determine on a case-by-case basis within the confines of the procedural bylaw. But certainly there may be situations. I think we left ourselves enough flexibility within the procedural bylaw. I don't have it in front of me, but I recall having this conversation. And it may be that, yes, in those exceptional circumstances, it would be that, staff would attend the property with the members of Committee of Adjustment and proceed on that basis. But I do recall in that one instance, I attended, there was no talking, it was all, so it was, it doesn't happen too frequently, but it is something that could be considered. Thank you.
Well, I'd be really happy with that. If we just have that option, if we really find that I didn't think we had that.
If there's one that's really contentious, then we could defer it. Or if staff felt that we should view it even before, we could do it. But that would get over it. But like to view every property when you're looking at it, it is quite onerous.
Excuse me, I realized I wasn't asking for that.
No.
It's for the ones that are
Yeah,
the
yeah,
exceptions.
well,
So
that's
that's great. We have that avenue.
Through you, Chair, it looks like I'm going to have to go back on what I said. It looks like the procedural bylaw, it indicates that members shall not undertake site visits of properties subject to a matter before committee, except when required under the Line Fences Act.
Okay.
So that was the flexibility that I recall having, but it just wasn't what I thought it was. It was with respect to the Line Fences Act. Thank you.
Can we amend that to exceptional circumstances? And then it becomes, I know it becomes a personal judgment. So probably not.
Through you, I'm hesitant to say off the top of my head here today, but if that's something that committee would like staff to investigate, we can consider that and return with a report. Thank you.
Sorry, I'm a very stubborn person. I still think that we should be allowed, if we ourselves have any confusion as a member of the committee, I'm not suggesting that we go to every single site, but just if I, for example, do not understand what's going on or have some concern or confusion, I think I should have the ability to go and see the site, just like many other committee members of adjustment do in other municipalities. I don't view it as something that, like, who am I going to speak with that would affect the quasi judicial nature of a single individual member of a committee of adjustment. It's not a meeting. It's just one person going out and fulfilling their obligation. That's it. So I don't think that the idea that the planning department could determine in advance that we should be going, I don't think that's going to happen realistically very often. And it's not going to address my problems, which sometimes are that I'm confused or I have concerns about an application and I want to go see it. And I think that we have the right to do that.
So to your point, Lisa, maybe we will or won't ask for a report, but if you're confused, it's probably a high probability that some of the rest of us are confused. So I think to Chair Edwards' comment, we get an application. If there's unanimous support that we need to see it, maybe that's that, and it would be deferred and we could go and see it. And I know that doesn't exist now, but I'm just wondering if that would be the way to do it. Or after getting here, like today, I didn't need to see that property after I had it explained to me. I really didn't need to go anymore. So
Well,
that's the other
this is
part.
why I was saying actually defer then, and I'll tell you, because like, and that I have had it come back at other times. We are not supposed to have any information. At one time, we didn't even get staff reports years ago. Everything was presented right at the hearing. It was a long hearing, but that's what they used to do. And then there was staff reports started coming in beforehand. But at one time, every staff report was just read out, just like it was done by what the planner for the applicant to make it fair. And over the years, they've changed. And I'll tell you, if you go to enough conferences, you will see one lawyer will say one thing and the next year somebody will say something else. And that, so it is up to the municipality. To me, it doesn't matter, like I say, like what everybody, because I'm used to both. Right.
Thank you, Chair. I just wanted to clarify to Member Bridgman's comment with respect to the potential of a deferral. I just wanted to make it clear that per the procedural bylaw, that wouldn't be allowed as it stands now. So if that was something that the committee was looking at reconsidering, that's something we could do. But I just think that we'd need to evaluate that at the staff level and return to you with our thoughts on that if that's something the committee wants. Thank you.
Yes.
Yes, I wanted to validate what you said with respect to the planning reports. It used to be that we did not even get letters. And if we had to see them all at the meeting, only with pressure did we change the way things were working in terms of getting letters of support or opposition from neighbors. Because to me, if you only have 14 days notice of an application and then your letter is not in an agenda package, if you're a neighbor, it unfairly biases everything towards the applicant. And we all know that the Planning Act already is doing that. And many changes or recent changes that have been made further have biased things in favor of the applicant. So I think if there's anything that we can do to improve the democracy of the Committee of Adjustment, we should do it. And I think site visits is one of the ways that we can better empower ourselves or tool ourselves to properly make decisions.
Yes.
Since we're all throwing our 2 cents in, I think this is a great discussion, by the way. I think it kind of validates the way that staff is operating and that they're operating well. Your comment just made that apparent, that once you came in and they explained it to you, you didn't see the need for a site visit. And at the conference, one individual who I specifically talked to about this, I don't know who it was from a different township, but they received their materials for their meetings significantly in advance of when we do. So they didn't get them on the Thursday before the Monday meeting. They got them well in advance. I know we're talking about doing something in exceptional circumstances, and I think that makes, that may make some sense. I don't think it would be, logistically possible for me to go and visit all these properties between Thursday evening and Sunday evening, and that's just not going to happen. So it might, I'm just throwing this out there. I don't think anybody wants to go this way, but if we were to go this way, I think we'd have to look at the whole entire process and see how that would need to be rejigged. And I'm not sure that's a feasible thing. So
one of the other things is if somebody comes in and they say, nobody visit my property after they've heard the one before them say, well, the committee were there, I didn't get fair treatment.
This
is why trying to treat everyone the same. It's very, very difficult. It's not just a cut and dry thing. But take like I say, if you figured out the kilometers that the staff are driving, if you could let us know. And that, so that if, like, when staff go out, they probably get mileage, don't they?
Well, through you, Chair, we actually have a planning vehicle that we use, a township vehicle, but
check the planning vehicle for the next one and just see how many kilometers they've actually traveled. And I think everybody's going to be amazed. Because I say, like, and that if you go to one, should you not go to the mall? Or, being fair is not going to the mall and getting the same thing. This is one of the things that, and I struggled with this when I first started, because I was used to going and starting at 7 o'clock in the morning until the 1 o'clock meeting and driving all over. And like it was for sometimes when they were changing some of the Planning Act, I think we started 6:30 one morning and then have lunch at the meeting, and then I think we finished at 6:30 or 7 at night. So there are advantages to both ways. And I'll let staff come up with the answers to that. I don't know, but I'm just pointing out the pros and cons as well. Is there anything else? I think we have an adjournment coming up. Moved by Member Grogan Green, second by Member Brown, be it resolved that committee of adjustment hearing adjourned at 11:40 a.m. And the next regular committee of adjustment hearing will be held Monday, July 14th, 2025 at 9 a.m. All those in favor? That's carried.